Picture this. You are standing in a federal building. Fluorescent lights, cold air, the smell of bureaucracy, and in your hands is a certificate, heavy paper, official seal, your name printed in black ink that will never fade. The officer shakes your hand. You raise your right hand. You repeat the words. And just like that, after years of waiting, filing, paying, praying, you are an American citizen. You walked in as a Jamaican. You walked out as both. That was supposed to be the ending of one story and the beginning of another. That certificate was supposed to be permanent, untouchable. The one thing no one could ever take from you. But what if it isn't? What if the government that handed you that certificate is now, quietly, legally, and without a single announcement on the evening news, building the machinery to take it back? Not from criminals, not from fraudsters, not just from people who did something wrong, from people like you. This is not a theory. This is not a rumor passed around in a WhatsApp group at 2 in the morning. This is documented. This is official. This is already happening. And if you are naturalized, if you or someone you love earned that citizenship through the process, then what you are about to hear changes everything. My name is Caribbean Docs, and today we are pulling back the curtain on one of the most consequential and least talked about shifts in American immigration policy in a generation. America is now taking back citizenship, and the Caribbean community is directly in the crosshairs. Stay with us. Every minute of this video matters. Let's start where this story really begins. Not with a law passed by Congress, not with a Supreme Court ruling, not even with an executive order that made headlines. It started with a memo, a quiet internal directive that most Americans have never heard of. It came from inside the United States Department of Justice, and it was called the Shomade Memo. Now, the word memo might not sound alarming. Memos get written every day. Most of them go nowhere. But this one was different. This one told federal lawyers across the country to prioritize denaturalization cases, to pursue them maximally, to make taking back citizenship a department-wide objective. Let that land. The United States government, the same government that administered your oath, printed your certificate, and welcomed you into the fold, issued internal instructions to its lawyers to find ways to undo what it did. That is not a government protecting its citizens. That is a government auditing them. And for the Caribbean diaspora, for Jamaicans, Trinidadians, Guyanese, Bajans, Haitians, people who migrated legally, waited patiently, and played by every rule in the book, this memo is a 5-alarm warning. Because here is what you need to understand about denaturalization. Most people think it's for the worst of the worst. Nazi war criminals, international fugitives, people who lied about genocide, and for most of American history, that was true. Denaturalization cases were rare. They were dramatic. They made the news. They involved serious crimes and ironclad evidence. But the Shomade Memo changed the threshold. It lowered the bar. And it opened the door to something far more dangerous than the high-profile cases of the past. It opened the door to civil denaturalization, and that is where this story gets terrifying. There are 2 ways the U.S. government can strip your citizenship. You need to understand both, because one of them has almost no protections, and it's the one they're now using. The first road is criminal denaturalization. This is the one most people picture. A trial, a jury, lawyers on both sides, a judge, evidence presented in open court. The government has to prove its case beyond a reasonable doubt, the highest legal standard in the American system. It's slow, it's expensive, it's hard to win. And that's exactly why the government doesn't like doing it this way. So they use the second road, civil denaturalization. No jury, no public defender assigned to your case, no reasonable doubt standard. Just a civil judge, the government's lawyers on one side, and you on the other trying to prove that you deserve to keep what you already legally earned. The burden of proof is dramatically lower. The government doesn't have to prove you're guilty of a crime. They just have to convince a judge on the balance of probabilities that something in your original path to citizenship was flawed. That's it. That's the whole standard. And here is the list of things that can qualify as a flaw. Gang affiliation, even an accusation. even a rumor from years ago. Financial fraud, human trafficking, a sealed arrest record you forgot to mention, a minor misrepresentation on a form you filled out a decade before, maybe in a second language, maybe without a lawyer, even a missing child's name. If your original immigration file doesn't reflect a child that existed, that discrepancy alone can be used as grounds for denaturalization proceedings. The language in the policy is intentionally broad. It has to be. Because the broader it is, the more people it can reach. And who does it reach most? It reaches the people who navigated the immigration system without resources, without legal representation, without the luxury of making sure every form was perfect. It reaches working-class Caribbean immigrants who did everything they were told to do, in conditions that were never designed for them to succeed. That is not an accident. Now let's talk specifically about why the Caribbean diaspora, and the Jamaican community in particular, faces disproportionate risk under this new policy framework. It comes down to how we came here. The vast majority of Caribbean immigrants arrived through family-based petitions, spouses sponsoring each other, parents bringing over children, siblings filing for siblings. These family chains are the backbone of Caribbean migration to America. And under the new enforcement posture, every one of those relationships is now a potential investigation point. Think about what that means in practice. A marriage that ended in divorce, even one that was completely genuine, where two people simply grew apart, can now be re-examined as potential fraud. A bitter ex-spouse can make a phone call. They can allege, with no burden of proof on their end, that the marriage was arranged for immigration purposes. And now you're defending yourself in civil court against an accusation about a relationship that may have been real, loving, and legally valid. Or consider the neighborhood question. Many Caribbean immigrants settled in urban communities that the federal government has designated as gang-affected areas. Not because they were involved in gang activity, but because that's where the affordable housing was, where family already lived, where the church was, the market was, the community was. But under the broad language of current denaturalization guidelines, living in or associating with individuals in a designated gang-affected area can be framed as furthering criminal enterprise. You don't have to be convicted. You don't have to be charged. You just have to be convincingly accused. In a civil proceeding with a lower standard of proof, that accusation can be enough. And then comes the outcome that stops rooms silent. If your citizenship is revoked, you are deported. But here is the part that nobody talks about openly. If your child became a U.S. citizen through derivative citizenship because of your status, your child's citizenship can also be challenged when yours is revoked, even if that child was born on American soil. Even if they have never lived anywhere else. Even if they are in high school right now, in Brooklyn or Miami or Hartford, with American friends and American dreams. That is not a hypothetical. That is current U.S. law, and that is the moment the story stops being about immigration policy and starts being about children. Policy without people is just paper. So let's talk about the real human cost of what's happening. Michael Roy Fraser came to the United States from Jamaica. He built a life. He had a child born in America. He became a naturalized citizen, but years before his naturalization, Fraser had entered into a fraudulent marriage to obtain his green card. When he later married his real partner and applied to bring her to the United States, federal officials uncovered the earlier fraud in the process. The result was swift and total. His citizenship was revoked. He was deported. And here is the lesson embedded in Fraser's story that goes beyond the personal. Fraser's case was not new. The fraud predated his naturalization by years. The government waited, reviewed, and then acted long after the fact, long after the man had built roots, had a child, had a life. There is no statute of limitations on denaturalization, none. The government can come for a citizenship that was granted 30 years ago. They can sift through paperwork from a decade before you became a citizen. They can find something you wrote, something you signed, something you forgot, and use it today. That is the power they now have. And they are using it. Fraser's not alone. There are people across the United States right now, in Caribbean communities who naturalized in the 1990s, in the 2000s, who are receiving letters, notices, court summons, people who thought the process was behind them, people who thought the certificate was the end of the story. It wasn't. For some of them, it was only the beginning of a different one. And then there are the people we cannot name, the ones who haven't had their cases made public yet, the ones sitting across from immigration lawyers right now, in offices in Flatbush and Brixton and Scarborough and Sunrise, trying to understand how a country they gave decades of their life to is preparing to send them back. We hear from them. We see the messages. We know they are out there. And every single one of them deserves to have this story told. Now let's talk about the people who haven't become citizens yet, because the danger doesn't begin after naturalization. For many, it begins the moment they decide to apply. The N-400 is the official U.S. citizenship application. It is the form you fill out when you are ready to take that final step. And right now, that form is full of traps that can end your case before it even begins and potentially flag you for removal proceedings you never anticipated. The questions are written in formal, complex English. And some of the most consequential ones hinge on the precise legal definition of words that are easy to misunderstand. Words like persecution, words like overthrow, words like member of or associated with. USCIS officers have been reported asking applicants to define these words during the naturalization interview itself, not as a language test in the traditional sense, but as a catch. If you define persecution loosely, in the way an everyday English speaker might, you could answer a question incorrectly without realizing it. That becomes a ground for denial, or worse, a flag for misrepresentation. The social media review adds another layer. Immigration officials are now screening the online history of applicants, posts from years ago, associations, groups joined, pages liked, comments made in moments of frustration or politics or youthful carelessness, now scrutinized as potential evidence of affiliations or beliefs that disqualify you from citizenship. And then there are sealed records, arrests that were expunged, charges that never led to conviction. In many U.S. states, the legal system tells you that sealed records don't count, that you don't have to disclose them. But federal immigration law operates on a different standard. Failing to disclose a sealed arrest on an immigration form, even one you were legally told to consider resolved, can be characterized as willful misrepresentation. And willful misrepresentation is a deportable offense. You may have spent years believing something was behind you. Clean slate, new chapter. The lawyer said it was fine. The court said it was expunged. But the immigration officer reviewing your N-400 does not have to agree. This is the new landscape. This is what the Caribbean community is walking into every single day, often without the legal guidance to navigate it safely. Here is something that matters as much as the policy itself. Maybe more. Fear. Not the fear of the people already in proceedings. The fear of the people who qualify for citizenship and have decided quietly, privately, at the kitchen table, that they are not going to apply. This is happening at scale across Caribbean communities in the United States right now. People with legal permanent resident status. People who have lived in America for 15, 20 years. People whose children are American citizens. People who have paid taxes, built businesses, coached Little League, and buried family members on American soil. They qualify. They have every legal right to apply for citizenship, and they are choosing not to. Because the risk feels too great. Because the stories have gotten around. Because someone in their church got a notice. Because someone in their family group chat shared an article, and now the idea of walking into a federal building and handing over every piece of their history feels like walking into a trap. And here is why that matters beyond the individual. When legal residents choose not to naturalize out of fear, they remain more vulnerable, not less. Permanent residents can be deported for offenses that citizens cannot. They have fewer rights in the political process. They have less standing to fight removal, and trying to protect themselves by staying invisible. They are actually making themselves more exposed. The fear is doing the government's work for it, And that is the quiet genius of this policy, if you want to call it that. You don't have to revoke 1 million citizenships if you can make 1 million people too afraid to apply for them in the first place. America is building a two-tier system: birthright citizens whose status is permanent and unquestionable, and naturalized citizens, the ones who came from somewhere else, who earned their status, who chose this country as much as it chose them, who are now living under a cloud of conditional belonging. We are Americans, until further notice. And that phrase, until further notice, should make every single person in the Caribbean diaspora stop and think hard about what they know, what they have, and what they need to do. Let's put the full picture on the table. These are the facts the mainstream media is not connecting for you. Fact 1. There is no statute of limitations on denaturalization. The U.S. government can open a case against your citizenship today for something that happened in 1994. No clock. No expiry date. 30 years of life built in America does not protect you if there is a legal imperfection in how you got here. Fact 2. One omission equals game over. Civil denaturalization does not require fraud or intent to deceive. It requires material misrepresentation, something relevant to your eligibility that wasn't accurately reflected in your file. A child's name missing. An address not updated. A question interpreted differently than you intended. One omission. One form. From years ago. That is all it takes. Fact 3. Statelessness is real, and it can happen to you. When your U.S. citizenship is revoked, you are expected to return to your country of birth. But citizenship in your birth country is not automatically preserved. You may discover your original citizenship has lapsed. You could, in a legal and documented sense, become stateless, a person with no country, no valid passport, no home to return to. Caught between a country that ejected you and a country that may not accept you back. This falls hardest on people who have been away the longest, who came youngest, who built their entire adult lives in America. Fact 4. Your entire financial future goes with your passport. Citizenship is infrastructure. It is attached to your Social Security record, your tax status, your job eligibility, your federal program access, your right to vote, your children's status. When it is revoked, it doesn't remove a document. It pulls a thread that unravels an entire constructed life. With no jury, no criminal charge, no public announcement, one civil proceeding, one judge, one ruling. These are not scare tactics. These are facts, and you needed to hear them. If you are still watching, it means this landed. It means you understand the weight of what we have just laid out. And understanding is the first step. But it is not enough. You need to act. Here is what action looks like, starting today. First, pull out every immigration document you have ever received. Every I-94, every green card, every receipt notice, every form you filled out, even the ones you think are irrelevant. The government keeps records. So should you. In a denaturalization proceeding, your paper trail is your defense. Second, disclose everything. If you are applying for citizenship, do not guess at what to include and what to leave out. The instinct to minimize your history, to skip the sealed arrest, to leave out the short marriage, to round off the dates can destroy you in a civil proceeding. Your truth, fully told, is always better than a curated version that contains a gap. Third, get legal help now, before you need it. Not after a notice arrives. Now. If you have an arrest in your history, a divorce during the immigration process, or if you ever lived in a neighborhood with federal gang designations, consult an immigration attorney. The time to know where you stand is not when the government is already moving against you. Fourth, talk to your children, especially if they are citizens through derivative citizenship, through your status rather than birth on U.S. soil. Their status is tied to yours. That is not a conversation anyone wants to have, but it is a necessary one. Fifth, share this. Because your cousin in the Bronx might not know, because someone in your church group is sitting on a sealed record they haven't thought about in a decade and are about to walk into a naturalization interview without knowing it could end everything. The Caribbean community does not have the luxury of staying quiet on this. We never have. Let's step back for a moment and look at what this really is. Because this is not just an immigration story. It is a story about belonging, about who gets to be permanently part of a country and who gets to be conditionally tolerated. Caribbean people did not stumble into America. We were recruited. America's healthcare system runs on Caribbean nurses and Caribbean doctors. Its service economy, its construction, the back of house of every hotel and restaurant in Miami, New York, Atlanta, sustained by Caribbean hands. We came, we stayed, we paid taxes, we built neighborhoods. We raised children who then served in the military of the country their parents immigrated to. And now the legal architecture of that country is being used to tell us that none of that is permanent. That belonging is conditional, that no matter how long you have been here, no matter how much you have given, you are still, at the end of the day, a guest who can be asked to leave. That should anger you. It should, because anger, properly directed, becomes attention. Attention becomes awareness. Awareness becomes preparation. And preparation is the only real protection any of us have right now. Before we close, we want to ask you something directly. If you are naturalized or you know someone who is, has this story changed how you think about your status? We want to hear from you in the comments. Did you know about the Shomade Memo before today? Have you, or someone in your community, already received correspondence related to citizenship review? And what do you think the Caribbean diaspora should be doing collectively, not just individually, to protect itself? These conversations need to happen in the open, because the ones happening privately, in kitchens and church halls and group chats, they need to get louder. If this video gave you something you didn't have before you pressed play, then do one thing right now. Subscribe to Caribbean Docs. We are building toward 100,000 subscribers, every one of them a person in our community who chose to be informed rather than blindsided. Hit the notification bell. Share this with your people, because the next video might be the one that saves someone from losing everything. The Caribbean diaspora needs more than community right now. It needs intelligence. It needs information. It needs to know what is coming before it arrives. That is what we are here to do. The certificate on your wall is real. The oath you took was real. The years you spent building a life in America, those are real too. But reality, as it turns out, can be challenged in a civil court, by government lawyers, without a jury, with no time limit, and the only thing standing between you and that outcome is knowledge. The passport in your drawer may not mean what it used to, but knowing that, truly knowing that, means you can fight back, you can prepare, you can protect yourself and the people you love. Don't wait for the letter to arrive before you take this seriously, because by then, the clock has already started. America is now taking back citizenship. Make sure it cannot take yours.